Welcome everybody. Thank you for joining us for our third accelerated webinar this week. Today we're talking about some property matters. So I'm Amanda Tolson, one of the directors here at Clifford Gouldson, and I head up the commercial and property team. So there's going to be time for questions at the end of today's webinar. So please send them through the questions panel, which you should be able to see on your screen. And we're going to keep answering some questions, even if we go over time this afternoon. So sorry, here's the slide where you can see where to answer the questions within the panel. Now, joining me for today's webinar is Brailak, who's a special counsel here at Clifford Gouldson. Carly's a highly experienced property lawyer who joined our firm last year, and we're very lucky to have her experience and expertise within our firm. So thank you, Carly. So what we're going to cover today, I don't need to tell any of you who've joined us that COVID-19's caused a great deal of upheaval for people all over the world, both in a personal and a business context. We've certainly had a very busy and unusual few weeks with most of our office working remotely and advising our clients on what they, how their business can operate in this really unusual time. In this webinar, we're going to be looking at the impact of the various government restrictions and announcement on commercial contracts generally, and both commercial and residential leasing. So within the commercial contract space is where we're going to start. The buzzwords at the moment are very much force majeure and frustration. So we'll cover off a couple of those concepts and give you a bit of information as to whether they might apply to your situation. We'll also look at your options where perhaps you don't have either of those and one party is in default under the contract. So I'll cover those and then hand over to Carly for the leasing part of today's webinar. And in commercial leasing, all the talk has been about the mandatory code of conduct, which was released by the federal government last Tuesday, right in the middle of our first webinar, which was great timing. So Carly will highlight the main points of that code and give you all some advice on what might be a reasonable way to proceed for landlords and tenants at the moment. Carly's also briefly going to look at what happens if the code isn't mandatory in your particular circumstances, and then review the situation for residential tenancies. Now, that's a lot to cover in 30 minutes, but we'll certainly do our best today. So the first thing that we'll talk about is force majeure. So a very generic summary is that a force majeure clause is a clause that allows a party to either avoid the contract or suspend the performance of contractual obligations under a contract when a certain event occurs that's outside the control of the party. And obviously it's a pretty useful clause to have at the moment. The purpose of these clauses really is to govern the parties' rights and obligations if something occurs that was really unforeseen at the time that the parties entered the contract. So normally it talks about fire, flood, storm, earthquake, actions of government. Then it can be also strikes or industrial action, war or terrorism, sometimes shortage of labour, shortage of materials. Diseases or pandemics are sometimes listed. We've reviewed quite a few contracts in the last month where it has not been covered. I've seen a few that they have. And so really the first thing to note is it's all about whether it's actually covered in your contract. There's no general or common law right to claim force majeure. So if you don't have the specific clause in your contract permitting it, you don't actually hold that right. And then, as I said, every force majeure clause is different. So you really need to look at the drafting and whether it covers the current circumstances. For a force majeure clause that doesn't list pandemic or disease as an event, a party might still be able to make a claim due to an act of government being mentioned, or even labour shortage or shortage of materials, depending on the circumstances. Certainly where government restrictions require your business to close altogether, acts of government is likely to be sufficient for you to claim that an event of force majeure has occurred. Another common event of force majeure is act of God. I've actually had so many times in my career where people have asked me, what does that actually mean? And to be honest, it hasn't actually been, or I certainly haven't seen it be implemented in that many circumstances. I'd suggest there might be some litigation coming up as to whether COVID-19 is an act of God. The internet has a lot of opinions about who it may be an act of, but it might depend on the drafting of the clause as to whether a party can rely on that to make a valid claim for force majeure in response to COVID-19. It's probably our suggestion that if you've got a different category in a force majeure clause, that you should probably rely on that rather than act of God. The other thing to note is if there is a force majeure clause, there's procedural requirements usually built into those clauses if you're going to claim that that event has occurred. Usually requires the giving of notice and within a certain time frame. So failure to claim within the specified time frame can invalidate your claim. So if you think you're affected by an event, you should check your contract as soon as possible to make sure you give the notice in the required time frame. A force majeure clause can then either result in suspension of the contract and then lifting, so effectively the contract being on pause, lifting of that suspension once the circumstances give rise to the claim no longer existing. Some clauses might allow a party to terminate a clause if terminate a contract if a force majeure event continues for a particular period. For COVID-19, we would expect that most events of force majeure would cease once the restrictions on movement are lifted and business and life start to return to normal. Contractual frustration, on the other hand, is a legal doctrine that actually applies to all contracts. Unlike force majeure, you don't need a specific clause in your contract that mentions frustration. Now, a contract is frustrated when its performance has become impossible or a party's obligations under a contract have become radically different to what was contemplated by the parties when the contract was formed. It doesn't apply simply because it's become more time-consuming or expensive for a party to perform their obligations. So the effect of a contract being frustrated, there's no sort of suspension concept. The contract's automatically terminated at the point of frustration, meaning that a party can't enforce the other party's future obligations under the contract. An example might be where a seller has agreed to sell a piece of farm equipment to a buyer, but before that contract can actually be settled, the piece of equipment's destroyed in a fire. The inclusion of a force majeure clause in a contract might actually prevent a party from claiming a contract's frustrated because the parties have incorporated a clause in the contract that contemplates otherwise unforeseen events and governs how the parties' rights will be adjusted if such an event occurs. So establishing that a contract's frustrated is a difficult thing to do. We've seen it being thrown around a couple of times in the last few weeks. And even where a party's unexpectedly put to severe financial hardship, the contract will not be frustrated. So for that reason, you need to be very careful if you're going to claim that a contract is frustrated, because doing so can actually amount to a repudiation of the contract by you. So repudiation happens when a party, by words or conduct, demonstrates an intention not to be bound by the contract. And the effect of that, so claiming that you've terminated the contract where there's no right to terminate, or claiming the contract is frustrated when it's actually not, actually gives the other party to the contract the right to terminate and claim damages. So you need to tread very carefully in terms of frustration. So in terms of default, what do we do if our contract's not frustrated? There's no event of force majeure, but the other party stops performing the contract. I don't want to steal Harrison's thunder. Harrison Humphreys is presenting a webinar this Thursday about enforcing your rights in the current circumstances. But we just wanted to touch on it today to again say the first thing you need to do is refer to the terms of your contract. It might require that before you take any action in respect of another party's default, that you're required to give a notice specifying the default in advance and giving them time to perform the contract in that reasonable time frame before you can then take steps to enforce. Your contract might also specify what your remedies are, or it might actually say that the parties are required to submit to a particular dispute resolution process. In the absence of that, there's the common law right for damages for breach. You'll be able to seek an order for specific performance, and you might be able to terminate the contract if the breach is significant enough. So if it comes to the point where you're serving demands on the other party, you should be aware that for the next 6 months at least, the timeframes for complying with a statutory demand and a bankruptcy notice have increased from the usual 21 days to 6 months to avoid companies being liquidated and individuals being made bankrupt in the course of this pandemic. But as I mentioned, Harrison will be discussing these in the next webinar on Thursday. So that's all we'll say about commercial contracts now. I'll ask Carly to move on to discussing leasing.
Okay, thanks Amanda. So as you may have heard, the federal government has now released a code of conduct to govern the relationships between landlords and tenants who are affected by COVID-19. The code doesn't apply to residential tenancies though. Um, so it's up to the respective state governments to legislate the code into law in their respective states. The Queensland government announced on Thursday that it was going to do just that. So I don't propose to go into every single clause in the code in this presentation because they're freely available. You can get a copy and read that for yourself. The code is mandatory where the tenant is eligible for the federal government's Job Keeper program, which requires that the tenant has a turnover of less than 50 million and has suffered a decrease in revenue of at least 30%. And that decrease in revenue must be as a direct result of the COVID-19 pandemic. So the code places a framework around negotiations that are now required to take place between landlords and tenants. And while it allows them to reach their own arrangements, there are some particular principles, I guess, that are mandated to apply during the pandemic period and any reasonable recovery period. So the one that everyone's, I guess, most aware of is that there's no more terminations for non-payment of rent. Landlords must offer tenants proportionate rent reductions based on the reduction in the tenant's trade during the pandemic. At least 50% of that reduction must be waived completely, meaning that the landlord's not going to recover that at any point in time. The other portion is deferred until after the pandemic period and a reasonable recovery period has passed. There is a minimum 24-month repayment period. So the tenant can generally defer that amount for the balance of the lease term, but where that term is less than 24 months, then that minimum period will apply. Landlords can't impose any fees, charges, or interest on unpaid or deferred rent. Landlords can't call on security that's provided by the tenant. So that doesn't matter whether it's a cash bond, a bank guarantee, or a personal guarantee. The tenant should have the opportunity to extend the term of the lease to facilitate that payment of the deferred amount or to reflect any period of waiver. No rent increases can be applied during this time, and landlords can't take any action against tenants for ceasing trade or reducing their trading hours as a result of the pandemic. So in relation to outgoings, I guess there's two different categories. Where there's a reduction in statutory charges, being rates or land tax or insurance, that must be passed on to the tenant. So obviously where those amounts are charged in addition to the rent, then they simply won't be passed on. But where the rent under the lease includes those amounts, then the rent payable needs to be reduced by the component of the rent that's made up of the land tax and council rates and insurance. The Queensland government announced on Thursday that they would waive land tax for affected landlords in the last 3 months of the 2019-2020 land tax year, and they would offer deferrals for the first 3 months of the 2021-2022 land tax year. But that's only where landlords comply with the code. And as of this morning, landlords could start to apply for that waiver and deferral. And there's a link you can follow. I'm happy to forward it to anyone if you wanted to get in touch. I can send that to you. In relation to other outgoings that aren't statutory charges or insurance, the code says that landlords should, where appropriate, seek to waive recovery of any other expense payable by a tenant under the lease during times that the tenant's unable to trade. So that might be relevant for businesses like gyms, restaurants, that kind of business who've had to shut down. The language used in relation to outgoings in the code isn't as strict as it is in relation to rent, and it just says that they should seek to waive those payments. I'd also suggest that where the tenant's still trading, outgoings can still be passed on subject to the specific rules about statutory charges and insurance. So what does all that mean for a tenant who can't pay the rent, or a landlord who's received a request from a tenant for rent relief? The first thing I'd say is that the government has stressed that the relief needs to be proportionate. So, and that's, proportionate to the tenant's downturn in trade. So both parties need to have adequate evidence about that downturn in trade in order to make an informed decision about the rent reduction that's going to be offered by the landlord. That information might actually change pretty dramatically during the course of the pandemic. There are businesses that haven't suffered any reduction in revenue at this point in time, but will definitely do so in the coming months. I'd suggest that if you're a tenant, when you're making a request for rent relief, that you should gather that information about your downturn in trade and present that to the landlord with your request. So the landlord can see that the percentage reduction that you're claiming is proportionate and justified in the circumstances. The code requires the parties to provide sufficient and accurate information to each other to enable them to make properly informed decisions in relation to rent reductions. So that information will include information generated from an accounting system. So for example, the tenant's accounting system to prove the downturn, or information provided to and or received from financial institutions. So that might relate to information that a landlord's given to their bank and the response received from their bank about what relief the landlord's going to get, for example, on their interest payments. So on the flip side, if I was a landlord and the tenant came to me and asked for a rent reduction and they didn't provide that information, that's the first thing that I'd be asking for. So you can make an assessment about how the pandemic has affected the tenant and make sure that the reduction that you're going to offer is actually proportionate. And it's completely reasonable to ask for that. Landlords should also be doing what they can at the moment to reduce their outgoings that they're paying to third parties, and so they can minimise those charges that are passed on to their tenants. So of course, some outgoings are unavoidable, but others are more discretionary in nature, or they might not be required as frequently. For example, if you've got a building that's half empty, do you really need to clean it as often as you did previously? As mentioned above, the Queensland Government has announced a program of waiver and deferral of land tax in certain circumstances, and pressure's also mounting on local governments to extend some relief on council rates. We'd suggest tenants and landlords to review the terms of their business interruption insurance to see whether their insurer will pay a claim in the current circumstances. It will very much depend on the specific terms of the policy, and it might be necessary to seek some assistance to work out whether the insurer is obliged to pay your claim. At the moment, we're aware that insurance might be looking to point to pandemic exclusions, but we've also seen some commentary from respected insurance lawyers that contradicts that view and suggests that perhaps insurers might be liable in the current circumstances. So we really recommend that you get appropriate advice in that regard and don't just assume that you won't be covered. The next step is really to negotiate in good faith and try and agree on the amount of rent reduction and the proportion of that reduction that will constitute a waiver of rent altogether. And some sort of arrangement obviously needs to be discussed in relation to outgoings, but without the benefit of that strict structure that the government has imposed in the code. A small non-legal suggestion that I have for you is just to remember at the moment that tensions are really high. There are a lot of people that are under immense pressure in a number of different ways, be it financial or otherwise. And the whole reason that you're even in this negotiation is because at least one party is in financial distress. So if there's ever a time to just be kind to each other and reasonable, this is that time. That's not to say that you need to forego your interests in favour of somebody else altogether, but it does mean that the negotiations can and should be conducted in a calm and reasonable manner, with a genuine effort made to try and reach a solution that works for everyone. And it might be that no one is completely happy with the solution, but if it gets everyone through to the other side, then maybe that's all we need at this stage. Once an agreement has been reached, it's our strong recommendation that it's written down and signed by the parties, preferably in the form of a deed. If the lease is registered on title, particularly where the term has been extended, it might be necessary to register a Form 13 amendment on the title. And where the term is extended, landlords should be careful to check the expiry date of any bank guarantee or bond that they hold from the tenants to make sure that that security doesn't expire before the new expiry date of the lease. And it might be necessary for the tenant to go and talk to their bank about getting an amended or updated bank guarantee that has a later expiry date than the one that the landlord already holds. Where the landlord and tenant genuinely can't agree on rent relief, then either side can apply for the matter to be determined for them in the form of a binding mediation. So we talked about circumstances where the code is mandatory. So there's a lot of leases that will obviously fall outside of that. You can still use the code for that to frame your negotiations. You're not obliged to. And also the Queensland government has provided a bit of a carrot for landlords to apply that code even if they don't have to, by saying that the land tax relief will only be available for landlords who comply with those new leasing requirements. So in that case, I guess the landlord would need to form a view about whether they're better off complying with the code and getting the land tax relief, or whether they're better off going outside of the code and making arrangements with their tenants. But if you are not going to get paid anyway, then you may as well get the land tax relief, I would have thought. So I'll now hand back to Amanda, and she's going to make some brief comments about residential tenancies.
Thanks, Carly. So that mandatory code that Carly just discussed doesn't apply to residential tenancies. So you might remember in some initial press conferences from Scott Morrison, he was talking about discussions about both, and it looked like the federal government might release some guidelines for both. In the end, they left it to the state governments to deal with their own residential tenancies, and that code is also being introduced in each state, but basically has been federally mandated. So the Queensland government then announced a package of measures to assist residential tenants who were affected by COVID-19. So central to that package is a freeze on evictions for any tenants who can't pay their rent as a result of the crisis, and that's backdated to the 29th of March. So similarly, tenants can't be evicted if their leases expire during the pandemic period, with property owners being obliged to offer an extension of a lease for at least the next 6 months. So this will be a watching brief. I imagine if this goes on even longer than that, the government's just going to extend that time frame as well. There's also a cap on penalties that can be applied as a result of tenants breaking their leases during this time. So it's only 1 week's rent penalty. So similar to the code, where landlords and tenants can't reach their own agreement in relation to rent relief, there's compulsory conciliation, which will be administered by the Residential Tenancies Authority, which is quite unusual. They haven't held powers like that previously, but they were obviously viewed by the government to be best placed to do this. You might have heard stories or on the news of property managers telling tenants to access their super or sell assets prior to the landlord considering a request of rent relief. That's now prohibited, and ASIC has also had something to say that they've published a warning to property managers telling tenants to access their superannuation constituted financial advice and would be a breach of the Corporations Act that would be prosecuted by ASIC if discovered. So the Queensland government's also introduced a rental grant of up to 4 weeks rent, or a maximum of $2,000 for tenants who are experiencing hardship, unable to access other payments or are waiting for those other payments to commence. And this is described as a last resort measure to prevent homelessness. So on the residential front, there's also some changes to residential tenancies where domestic violence is present. Unfortunately, domestic violence tends to increase in difficult financial times, and you might have all seen some discussions, the current circumstances really exacerbating restrictions of movement, which require perpetrators and victims to remain at home. And job loss is also really compounding that situation. So all of those circumstances sadly result in an increase in the support needed by domestic violence victims. So the Queensland government announced on Thursday that they've got some new protections for victims of domestic violence, which allows them to terminate residential tenancies on short notice, change locks without approval, access their bond, and also separate from co-tenancies. So the Queensland government's launched a website called the Residential Rental Hub to be a central point for landlords, tenants, agents, and property managers to find information specific to them in relation to COVID-19 and residential tenancies. So I'd pop over there and have a look if you need some more information. So we'll now move on to questions. Now, some have been submitted in advance of today's webinar, which we might cover first. So the first is, how do we treat outgoings in a commercial lease with regard to the government's guidelines for negotiation with tenants, are outgoings included, in the 50-50 equation? So Carly, I might throw that to you to answer.
Okay, so we covered outgoings a little bit above. The short answer is no, they're not included in the 50-50 equation. Any savings by the landlord for those three that we discussed, which is the statutory charges, land tax rates, and insurance, must be passed on to the tenant. With other outgoings, it's a bit less clear. Landlords should seek to waive outgoings altogether if the tenant isn't trading. However, there's nothing in the code that would prevent a landlord from charging outgoings if they had to, whether or not the tenant is trading or not, or if the tenant's trading at a reduced capacity.
Thanks, Carly. And then the next question we've actually had quite a few times. What about rental arrears that existed prior to COVID-19? We've unfortunately had a number of people sort of approach us in terms of this, even some suggestions that tenants who may have had long-standing arrears are almost using the current circumstances as an excuse. So Carly, I think our view is the wording of that code suggests the prohibition only applies in relation to rental arrears resulting or sort of arising during the pandemic period, and there's that subsequent recovery period you mentioned. So on the information we've got at the moment, we would expect landlords could enforce breaches that occurred prior to that period, but it might be prudent to wait and see, wait for the Queensland legislation to actually be introduced to Parliament here, that will have some more detail in that regard. But I guess the other pragmatic thing that Carly and I have discussed is if you have a tenant who might have been in breach but is still paying some rent as well, the other thing to consider is if you decide to take a step and terminate them and you were able to, because it's a pre-existing breach, are you going to be able to procure a new tenant at the moment anyway? Is, I guess, something to consider. So that third question, what if my tenant asked me to use their security to satisfy their obligations under the lease? Carly, you mentioned security being untouchable, I guess, in your rundown of the code. What's your view on this one?
Again, the language of the code is also relating to breaches of the lease as a result of the pandemic. So, look, to be honest, we're hoping that the legislation, when it comes, is a bit more clear about this, and particularly whether they can contract out of the code. So, if a tenant asks the landlord to use the security, then can they agree that that's fine, even in respect of breaches that occurred during COVID? A situation I've seen is where the tenant has literally thrown the landlord the keys and said, I've got no money, please take my bank guarantee, let's call it quits. The landlord would love to do that, but at the moment, if those breaches are as a result of the pandemic, they can't do that as far as we know. So for arrears that existed prior, I think the better view is that landlords can call on security in respect of those breaches. In terms
of financing arrangements as well, Carly. I mean,
Yeah, that's right. Yeah, if a tenant has a bank mortgage or something like that, or a loan, it may actually constitute an event of default under that facility if the landlord calls on that guarantee. That might also apply if that tenant has given a guarantee for another party's facility. That might also constitute a breach under that other third-party facility as well. So it's not really recommended for tenants to ask a landlord to use their security at this point in time, particularly because they've got that rental waiver up their sleeve that if they can trade out of it, then they might have an opportunity to.
And then another question I think we received just when we started the webinar, if a tenant's on a month-to-month arrangement, is the rent required to go down immediately and by how much? I think, Carly, again, on the view, the reading of the code, it's sort of couched generally enough that we think it does capture even periodic arrangements. You agree with that?
I do. The code doesn't make any distinction between month-to-month or long-term or short-term or any other kind of arrangements. If you didn't want the rent to go down and you'd prefer the tenant to move out, then if it's a month-to-month, you can just give a notice for no reason, ending the tenancy at the end of the next month. The question about how much, again, the code applies. It's got to be proportionate to the tenant's downturn, and I reiterate my comments before about getting appropriate information to make that decision. In terms of any component that's deferred, the tenant has to have a reasonable opportunity to pay that back, and there is that minimum 24-month term to pay that any deferred amounts back. So if the tenant is on a month-to-month arrangement and you might want that to continue, now might be the time to start talking about entering into a fixed-term lease for the expected duration of the pandemic plus 24 months.
And for anyone who's watching Scott Morrison's press conferences like a hawk, like we were, he actually made a mistake when he was summarising the code last week, and he actually said tenants only had to have a 12-month period, I think he said, Carly, to repay. And then when we've looked at the code, it's actually 24 months, which probably makes a bit more sense, I guess, in terms of having enough time, having enough time to actually repay those sorts of arrears.
Yep.
So look, we've hit 3:30. So if you need to leave, please feel free to access the recording afterwards. Carly and I are going to stay on and answer these questions that have come through. I think while we've been on the webinar. So that first one there, landlords are now required to give rent relief to tenants based on that percentage decline in turnover. To my knowledge, there's nothing stated about the tenant having to prove the percentage turnover. So as Carly mentioned before, you do need to provide some financial information from either the bank, I think you said, Carly, or a financial management system. Yeah, your accounting system.
Yep.
So again, I mean, I think it's really incumbent on landlords to get a copy of the code. Here's one I prepared earlier. I think it's 7 pages long, isn't it, Carly?
That's right.
So,
yep.
I mean, this is the general summary. There is going to be legislation which no doubt will be longer and more complex and drafted by, some clever government lawyers, but this is quite palatable at the moment. So I'd really encourage you to pick it up and have a read. It sets that out in there. So I think that you can definitely push back and ask the tenant to demonstrate that. And that's the advice we're giving to both our tenant and landlord clients. So tenants can't be evicted during this period because they're not paying their rent. Is this the only point they cannot be evicted? So I think that question's asking if there's any other reasons. So for example, if they caused damage to the premises, could they, I guess, do the normal rules still apply? Carly, I think our view is that they do. So the code is not trying to allow tenants to go rogue and do whatever they want for the next 6 months. It's only in relation to the non-payment of rent, or those other specific points that are restricting what the landlord can do, increases in rent and those sorts of things. I guess outside of that, the normal rules still do apply. So again, just make sure you seek some advice, and I would want to tread very carefully that you're not I guess, accused by a tenant of using something else as an excuse when rent is really the problem. You would just need to tread very carefully in giving that notice. And that it's a 6-month period at the moment, isn't it, Carly, when you can't terminate for rent arrears at the moment.
The pandemic, it talks about the pandemic period, which is defined as the period during which the JobKeeper program is operational, and that program is at the moment from the 30th of March to the 27th of September. There are parts of the code also that refer to a reasonable recovery period, and that's the unknown. I guess that is very much going to depend on the nature of the tenant's business, how quickly things return to normal after the pandemic period, ending at the moment on the 27th of September, how long it takes for life to return to normal. And I guess the other point that we haven't made so far in relation to deferred rent in particular is that the parties can't make some kind of arrangement that would actually put the tenant into financial distress or make them unable to comply with their obligations under the lease during that period that the deferred rent commences being paid. So there needs to be consideration given to, I guess, how much extra the tenant can absorb at that time on top of the rent commitment that then kicks back in.
So, Carly, if we had a 50% rent reduction, or, let's say you waive 50% and then you forego the rest, you can't have a balloon at the end of the 6 months, which would just mean that there's a trigger of default when they can't pay 50% of rent over a 6-month period. So effectively 3 full months rent starting from September, which is going to be very unlikely.
Yeah, well, there's that minimum 24-month period.
24 months.
Yeah.
Yep.
So they've got 24 months, but if there's so much deferred rent and they had really small margins on their business to start off with, that might govern how you introduce that deferred rent later on.
Yep. And so breach notices, can we still enforce a breach or eviction notice for rent arrears prior to 1 March? I guess the answer there is yes, the code seems to apply only to those after that point in time. I guess my normal caution, if we're talking about before 1 March, if there was actually a notice to remedy breach issued before then, it may have lost currency. So I would consider what you need to do about it, about perhaps potentially reissuing. But in relation to outstanding rent before that period, it is our understanding from the code that that's still able to be enforced. And then the fourth question there, tenants must abide by their lease agreement other than pay their rent during this period. When does the period end? So that's the September timeframe you mentioned, Carly.
Yep, plus a reasonable recovery period.
And as I mentioned, I think it's probably reasonably foreseeable that that may be extended. I think the government's making their best guess, as we all know, on how long this is going to go for. But there's every chance that if it goes for longer than they are currently anticipating, they'll jump in and change these dates, and these things may be in place for a little bit longer. We've got another question slide that's just popped up.
Okay.
Oh, it's specifically for Carly. Excellent. I can relax.
I just want to verify the treatment of rates and insurances. Do I include these outgoings in the equation for the mandatory code of conduct, or is it just the rent and the tenant is liable for council rates and insurance? Also, I pay some insurances and the tenant has their own insurance. Are they lumped together? Okay. They're not included in the rent. I guess there's two types of leases, obviously. One you have the rent plus outgoings, and then in another you have the rent including outgoings. So I guess for your rent plus outgoing scenario, you just can't pass that on at the moment, where you get reductions in land tax or rates or insurance from those third parties. So yeah, look, outgoings are just treated differently. I guess it's not included in that rent equation, which is the waiver and deferral. So in relation to the council rates and insurance, the tenant can be still made liable to pay those. The code says that the landlord should seek to waive, other insurance, other outgoings where the tenant's unable to trade, and they should reduce those outgoings wherever possible. But there's nothing stopping those other outgoings from continuing to be charged. The language is much less strict. There's no forced waiver of outgoings except for those statutory charges and insurance. The tenant, where they have their own insurance, that's their expense. It's got nothing to do with the landlord. You don't need to talk to the tenant about their own insurances. This is just those insurances that the tenant is required to reimburse the landlord for as an outgoing under the lease.
So number two there.
That answers your question.
Thanks, Carly. What impact will the code have on CPI rental increases for commercial leases? So that's definitely very clear in the code that there will be no rent increases except for retail leases based on turnover rent. But otherwise, so CPI rental increases, you can't apply those increases. For the duration of the COVID, I'm reading now directly from this the code for the duration of the COVID-19 pandemic and a subsequent recovery period. So again, I think that reasonable subsequent recovery period may depend on the type of tenant that you have. Carly, is that your view of that? The way they've described that? So you need to really be careful when if you've got one coming up in 6 months, I think you need to carefully, or more, 8, 9 months, you need to think carefully about whether you can actually introduce it at that time.
I would also say too, next time you do a rent review, to look very carefully at the terms of your rent review clause. Generally, they will only talk about a CPI increase, will only talk about CPI increases back to the last year. But depending on the wording of your clause, you might be able to backdate that to the last CPI review, which would have been before the COVID pandemic. So look, I don't know, I guess I'm just thinking out loud, but next time you do a CPI review, I would review the terms of that clause carefully to actually work out what your base CPI you're adjusting from for that rent review.
And then that last question there, Carly, I don't think that the code actually has a definition of what is a lease. You
No.
know, as lawyers, we always go to the definitions, but this sort of 7-page code doesn't have the complexity that the legislation's going to have. So I guess at the
Mm.
moment, if there's no written lease agreement in place, Carly, I think we would suggest caution and assuming that you do fall under the code.
Yep.
And then, you know,
You can,
um,
yeah, you can have a lease by conduct.
mhm.
Um, you can have a lease. People have been deemed to have a binding agreement because they've exchanged a few emails and they've conducted themselves in accordance with those emails for a period of time. So I wouldn't assume that if you don't have a lease agreement that you're not caught.
And I think that might be the end of our questions. So if that's the case, thanks. That's all we've got time for today. Don't hesitate to contact Carly, myself, or any other member of the team at any stage if you require assistance, even if you just want to have a high-level chat. We've been pretty busy in the last few weeks having those general chats, I guess, particularly before the code came out, with people wanting to know what we thought Scott Morrison meant, which, we were having our best guess, and now at least we've got the code, and now we're just waiting on the Queensland Parliament. I thought I'd mention our upcoming webinars in the series as well. As I mentioned, there's one on Thursday with Harrison about enforcing your rights. And then we've got also some coming up with structures and estate planning with Sheila Gray. And you can see some there as well, new business and construction coming up after that. So just a quick reminder, if you missed our previous webinars, they're also available on YouTube. So there, Danny did one, Danny Clifford did one late last week on workplace issues, which is another hot topic. So thanks for joining us today, everybody. We wish you all the best in these difficult times and stay safe. Thank you.